Dassow. We respectfully request that this court vacate the summary judgment for the following reason. There is sufficient evidence to create a fact issue for trial that Dr. Dassow treated Ms. Parker for personal gain in the form of salary and malpractice insurance paid by Erlanger. Let me repeat, paid by Erlanger. This case is about a delayed diagnosis. Ms. Parker was pregnant with Orrin, visited Erlanger for a fetal ultrasound. That ultrasound detected an abnormality called a meningocele, which is a hole in the spine. If this is detected in utero, fetal surgeons can repair it, and the child can be born normally. In this case, Dr. Dassow interpreted the imaging as normal. She was wrong. As a result, Orrin Parker was born with this meningocele untreated. He'll never walk independently, and he has spina bifida due to Dr. Dassow's negligence. There are three fundamental principles of personal gain in this case under TCA 9-8-307H, which undermine Dr. Dassow's immunity defense. Number one, personal gain is personal gain, whether it's received directly or indirectly by Dr. Dassow from Erlanger in exchange for treating patients. Erlanger paid all her compensation, and she treated patients exclusively for Erlanger. Number two, personal gain is personal gain when Dr. Dassow received it by treating Ms. Parker in August of 2018. Dr. Dassow cannot repudiate personal gain retrospectively to avoid liability. Doesn't work like that. And number three, and this is really important, personal gain is personal gain whether Dr. Dassow was a dual employee of Erlanger or not. Dr. Dassow has conceded this point in her brief. Why is this so important? The trial court ruled that he would have found personal gain had Dr. Dassow also been a dual employee of Erlanger. Court would have also found that Hayden versus Waller would have controlled this case had she been a dual employee of Erlanger.
Excuse me, counsel.
Yes, sir.
For interrupting. Could you address, it's my understanding in this case there was an affiliation agreement.
Yes, sir.
What bearing or impact does that have with regard to the issues in this case?
I believe the affiliate agreement provides facts that support the plaintiff's contention that there is a factual dispute because there was a symbiotic relationship between Erlanger and the University of Tennessee, strikingly similar to the agreement between the University of Tennessee and the medical group in Hayden versus Waller. It's one of the reasons why Hayden and this case are so closely matched with each other. And there were duties and responsibilities set forth in the affiliate agreement, Judge. For example, I told you that Dr. Dassow served Erlanger exclusively when treating patients. That's in the affiliate agreement. The affiliate agreement also specifies Dr. Dassow's income consisted of money that Erlanger collected from her treatment of patients. That creates the chain of personal gain. She treats a patient, submits a bill, Erlanger sends it to the insurance carrier reimburses Erlanger, Erlanger puts money in the stream of income, Dr. Dassow gets her salary.
This is all, I'm sorry,
Sure.
I apologize.
I'm sorry.
One of you go ahead.
Mr. Kelly, my question is, as I understood this, there's a contractual relationship between Erlanger and UT such that Erlanger is paying a fixed amount of money to UT regardless of how many patients Dr. Dassow treats. Is that correct?
Yes, sir, and also paying for Dr. Dassow's medical malpractice insurance coverage, $15,470 of it.
But there's no impact based on the number of patients. In other words, regardless of how much money Erlanger collects from Dr. Dassow's services, that amount doesn't change between the amount of money that Erlanger pays UT. It doesn't go up, it doesn't go down based on either based on the number of patients or how much money Erlanger collects from her treatment?
Correct. There's no evidence that the volume of patients that Dr. Dassow sees will affect her salary up and down any different than the fact is the salary is paid to see patients. But that's exactly the situation in Hayden versus Waller. Dr. Hayden said it had a contractual relationship where he was being paid over $100,000 in salary to see patients at the Med. He got no bump in pay or had no volume agreement for treating Ms. Waller. But this court had no problem finding personal gain in that situation. In fact, what the court said was because Dr. Hayden made a salary, a fixed salary, for treating Ms. Waller, who, by the way, Your Honor, Ms. Waller didn't even pay money to Dr. Hayden. This court found that was sufficient evidence of personal gain because he was being paid by a third party, which is the distinguishing feature we contend in this case. The money is coming from a third party. There's no mistake about that. This is Dr. Dassow's Rule 56.03 reply that she submitted to the trial court. Please admit Erlanger contracted to pay $109,970 annually for Dr. Dassow's professional services that she provided at Erlanger's clinics. Money was distributed through UT. Answer, undisputed for the purpose of summary judgment. Number 16, Erlanger contracted to pay $15,476 for Dr. Dassow's professional liability insurance, which was deemed part of the fair market value of her compensation. Answer, undisputed for the purpose of this motion. And finally, Dr. Dassow cooperated in billing and collection of all amounts due for her professional services. Answer, undisputed for the purpose of this motion.
Was the money that Erlanger paid to UT, was that just a pass-through? In other words, did Dr. Dassow receive those funds? Or was that money just between Erlanger and UT, or do we know?
This is why it goes back to Judge Friars' question about the affiliate agreement. The affiliate agreement specifies in its recitals her income consists of money that Erlanger captured in revenue from her treatment of patients. Therefore, her salary consists of the money that she generates for Erlanger. We don't know to this day how much money UT pays to Dr. Dassow, other than her saying that the money comes from UT. But we do know some of that money comes from her services at Erlanger, which again was similar to what happened in Hayden versus Waller.
The trial court distinguished Hayden, didn't it?
Yes, sir, it did, based on dual employment.
Well, based on the fact that in Hayden it was a private employer, right?
Yes, sir.
And in this case, the trial court found that that's not the situation here. We don't have to worry. This is not a situation where a doctor set up a entity over here, a private entity, to protect himself or herself. They said this was a public entity, UT. And that was the distinguishing factor, wasn't it?
Yes, sir.
As far as the trial court was concerned.
As far as the trial court was concerned, because Erlanger...
Why is the trial court wrong about that?
Well, as I understand the Appellee's brief, the Appellee agrees that dual employment does not provide a prerequisite for attaining personal gain. That's my understanding of their concession at page 27 of their brief. So if dual employment is not a prerequisite to personal gain, then we're back to the simple question, did Dr. Dassow receive personal gain when she treated Ms. Parker? That's the question we contend the statute poses.
If he had not treated her, would the doctor have received any less?
Well,
is there anything in the record? We've got the affiliate agreement that says what Erlanger pays. Is there anything in there that raises an issue of whether or not the doctor would have received less payment from UT if he had not seen this patient?
Judge, just like any salary, we look at a situation when someone's paid for a service. We don't look at if they don't show up, what do they get less? She's paid a salary just like Dr. Hayden was.
So the answer is no.
The answer is no. That's exactly right, Judge. I'll be completely candid. And you know, I'll be completely candid with Your Honor. If you find she has to get a bump in pay, or that she would lose something by not treating Ms. Parker, we don't have any evidence to support that. Our position is, it's the affirmative. Did she get something for treating Ms. Parker? And the point that we're making is she got salary and she got malpractice insurance coverage, which, by the way, was something she couldn't even get from UT. The affiliate agreement, Judge Frierson, it prohibits UT by policy from paying for or providing her malpractice insurance coverage. So every time she sees a patient at Erlanger pursuant to that agreement, she's got malpractice coverage, which we contend is a personal gain. It's a benefit to her. So our contention is every time she sees a patient at Erlanger, she gets paid a salary for $109,797 plus $15,476 in malpractice insurance benefits. Your Honor, by the way, she gets a separate salary of $25,207, and that's paid for academic precepting services. So she's getting paid in two different capacities. And that's another contention we make here is, my understanding of Hayden, if a doctor serves in different capacities as a physician treating patients, that makes the difference in whether or not there's personal gain. In this case, it's undisputed Dr. Dassow treated Ms. Parker pursuant to the affiliate agreement. It was medical practice, no residents involved, no interns involved, no UT involved. UT wasn't involved in this at all. Whereas if she had been precepting a resident, teaching, let's say, for example, or in the hospital showing a resident how to perform a procedure or giving a student advice on how to do this test, that would be in her capacity as a state employee serving UT. We contend she's not serving UT when she's treating patients at Erlanger. I see my time is up. Thank you.
You have your time for rebuttal. Thank you. Here from the Appellee.
Good morning, Your Honors, and may it please the Court. My name is Christopher Vrettos of the Williamson County Bar. I'm with Cumberland Litigation. I represent Dr. Dassow in this matter. This is a really simple case. The sole question that this court has to answer, and it was already answered by the trial court below, is did Dr. Dassow receive personal gain relative to her interpretation of the ultrasound at issue? And the answer is no, she did not. Now, Mr. Kelly has referred repeatedly to the salary that was paid by Erlanger, but what went unsaid in his argument is that all of the payments made by Erlanger, whether they were designated as for teaching, whether they were designated as for providing medical services, or whether they were even designated as for medical malpractice insurance, all of those payments were not made to Dr. Dassow. They were made to UT. That can be found on page 66 of the technical record. It's the Exhibit A attachment to the affiliate agreement where Erlanger lays out this is what we're going to be paying, and the statement is made specifically that these payments are being made to the University of Tennessee.
Counsel, excuse me for interrupting. With reference to the malpractice insurance premiums, did Erlanger pay those premiums or the value of those premiums to UT, or did Erlanger pay those premiums directly to the carrier?
No, those payments, according to the affiliate agreement and the wording of the affiliate agreement, all payments are designated as being made to the University of Tennessee. So Dr. Dassow's salary in this case, what she was actually paid, came from the University of Tennessee, which of course is a department of the state of Tennessee. And so, as a state employee whose salary is compensable by the state of Tennessee, that entitles her to absolute immunity under 9-8-307H. And with respect to the Hayden versus Waller case, Your Honors, I submit the difference there. The reason this whole issue of dual employment came up, not because it's a prerequisite to finding personal gain. It came up because that was the factual pattern in the Hayden versus Waller case. The doctor in that case was employed by both the state and he was employed by a private medical group as well, UTMG, and he received salaries both from the state and from the private medical group. And his contract in that case, it was a letter rather than a formal affiliate agreement, but his contract in that case was different in a key way. It specifically excluded from its ambit patient care. His contract to provide services for the state was exclusively to supervise residents and to head up the residency program at the hospital.
Ms. Vrettos, let me ask you a question.
Sure.
Did she have any discretion as to whether or not she would perform services at Erlanger, or does the record reflect that was part of her employment with UT? I assume it was for working with residents at the hospital, or was it? I'm not sure what it was, but my question is, was it discretionary, or was that part of her work for UT, required work for UT?
Thank you, Your Honor. That's a very good question. No, it was not discretionary. It was, in fact, what UT contracted her to do at Erlanger. She was contracted in distinction from the Hayden versus Waller case. Dr. Dassow was actually contracted to do both things, to teach residents and to perform patient care when needed. So she did not have the option of just saying, you know what, I am not going to read this ultrasound, because it was in the contract that when this comes up, you're going to do it. So was she acting within the scope of her employment with the state? Of course she was, because that's what the state contracted her and the other physicians at UT to do at Erlanger. So going back to the comparisons with the Hayden case, the key in the Hayden case was that because that doctor had two different salaries, it was found that the salary he got for treating the patient came not from the state, but from the private entity, UTMG. And this is the linchpin of the entire Hayden case, and this is what makes it different from this Parker versus Dassow case. So long as the physician is receiving payment from an employer other than the state of Tennessee to perform the work in question, he is not entitled to immunity. So in the Hayden case, Dr. Hayden was getting paid by a private entity for his work. And because he had that private pay for the work in question, that was the issue of the lawsuit, he was not entitled to immunity. Dr. Dassow, on the other hand, receives 100% of her compensation from the state of Tennessee. Now, the argument will be made and has been made, well, this was just a siphon. The state of Tennessee may have actually paid her, but we all know that that money was coming from Erlanger. It's right in the contract. Erlanger is paying this money to UT. There is a federal case, and of course, since it's a federal case, it's not binding upon this court, but it is persuasive authority, and I am not aware of any Tennessee cases which contradict this one. But the Thompson versus Regional Medical Center case, the exact same argument was made, where you had a bunch of residents at the hospital, they received their pay from the state, and the plaintiff in that case said, well, wait a minute. This hospital is actually reimbursing the state. So, really the money is being paid by the hospital. The court rejected that argument and said the statute, and the statute it was referring to was the statute that defines what an employee is for the purposes of the Claims Commission Act, 8-42-1013A. An employee is somebody who is employed in the service of and whose salary is compensable by the state. And the court in the Thompson versus Regional Medical Center case said that statute is entirely silent on the source of the funding. And the case is to be decided by the statutory language. And since these residents are paid by the state of Tennessee, they're entitled to immunity. And it matters not that the hospital pays the university, who then turns around and pays the residents.
Is there any, basically the same question I asked Mr. Kelly, was there anything in the record to indicate that her salary was impacted by the volume of work she did, by either little work or a lot of work at Erlanger? Number of patients, volume of patients, anything like that, volume of services?
There is not, and as a matter of fact, the evidence is actually the opposite. I believe it's section 5.6 of the affiliation agreement that says that the amounts of the payments that are discussed in this contract shall not vary regardless of the volume of the work, regardless of any referrals. So the rate that Erlanger pays to UT is the flat rate. Shall not vary. So, whether Dr. Dassow did this particular ultrasound and it was, one more than she had done under a normal month or week or what have you, she doesn't get extra compensation for that. Or rather, Erlanger doesn't pay UT extra compensation for that. Similarly, based on that shall not vary language, we can look at that and say, well, if she hadn't done this particular ultrasound, Erlanger is still going to end up paying UT the exact same. So there is no variance in answer to that question, Your Honor.
Counsel, I may have misunderstood Mr. Kelly here, but as I understand, he said that you admitted in your brief that the doctor was a dual employee.
No. Not that she was a dual employee. The question is simply...
And I may well have misunderstood.
That's quite all right. I think what the argument being made is look, personal gain is personal gain. You don't have to be a dual employee for personal gain to exist. And I agree with that. Statute says nothing about dual employment as a requisite to finding personal gain. The reason, again, that dual employment came up was simply because those were the facts of the Hayden versus Waller case that Mr. Kelly is relying on and is saying governs the outcome in this case. The doctor had two salaries, one state, one private, and it was the private salary that took away his ability to claim immunity. Well, that doesn't exist in this case. There is no private salary coming from anywhere. Dr. Dassow is solely an employee of the state. So we can't look for personal gain for a salary coming from a private entity. If there's any personal gain, we have to look for it elsewhere, which I think all the questions about whether the salary would have gone up or down had she not read this particular ultrasound, that's where those questions come in. And the answer is there personal gain anywhere else? There isn't. Erlanger doesn't pay her, it pays the university. She derives all of her income from the university, so she fits squarely within the statutory definition of a state employee. She is there at Erlanger doing the work that UT contracted her to do, and therefore she is entitled to claim immunity in this case. And I submit to your honors that the trial court's ruling in this case was entirely correct. One thing I do want to address, I haven't heard it come up yet, haven't heard any questions, but there is this one issue of a statement by a BCBS claims processor who says, well, we wouldn't have paid this unless Dr. Dassow had billed for it. And that is one statement out of an affidavit where this very same claims processor admits that who submitted the bill? Erlanger Health System did. Who got paid for the bill? Erlanger Health System did. This billed for language comes in because Dr. Dassow, as part of her contractual requirements, had to cooperate with Erlanger and provide. She was the one who interpreted the ultrasound, so she gives them her provider number so that they can bill for this service. But that does not mean that she received any benefit from it. She gave them her provider number so they could bill for it. Erlanger billed for it. Erlanger got paid for it, but there was no personal gain on Dr. Dassow's part. There was also the statement made by Mr. Kelly about sort of the pool of funds. And what the affiliate agreement says exactly, and I believe this is in the early portion, perhaps the recitals, is that we acknowledge that a portion of the payments described here under at least a portion is coming from the services provided here. So it's not an issue of a siphon where Dr. Dassow interprets an ultrasound and then Erlanger bills for it, Erlanger gets paid for it, and they siphon that money back to her. No, it's just a situation where perhaps some of that money, and we don't know how much because all the affiliate agreement says is a portion, some of that money goes into a pool, and out of that pool, Erlanger is paying out these flat rates to the university, and then the university, of course, turns around and pays its own physicians. So I submit that loan statement by the claims processor does not create a genuine issue of material fact, even when viewed in the light most favorable, the legitimate light most favorable to the plaintiff. I have actually made my argument, Your Honor, so unless there are any other questions for me, I will let Mr. Kelly take the rest of his time.
I hear none. Thank you. Mr. Kelly, you have time for rebuttal.
Since he ended on this, I'll start with this in my rebuttal. The question here is, are there sufficient facts to create a fact issue, not whether we're going to win a jury trial over this. We do have testimony from Mr. Rick Moore, who said Blue Cross Blue Shield would not have paid the claim unless Dr. Dassow had billed for the radiological service according to the billing guidelines or requirements. Again, going back to Judge Frierson's question, the affiliate agreement required her to assist and cooperate in billing, and that's precisely what she did here. It's at record 164. That is some evidence that she's working for her personal gain.
How is it evidence that she's working for her personal gain?
Because if she's, sure, Judge.
UTs or Erlangers or whomever, I mean, her personal gain. The fact that she's required to submit a bill under her ID provider, her provider ID, for the service she performed, how does that show that, I mean, your statement that that's some evidence of personal gain, how?
Sure. Judge, you can infer that by virtue of presenting a bill, Erlanger captures the money. That money goes into the pool that goes into her salary. It pays her salary. If she's not billing patients and capturing money, how long is Erlanger going to keep paying her? I mean, I think one thing that's gotten lost in this process, who is Dr. Dassow working for? It's clearly it's Erlanger. I mean, she says she treats patients exclusively for Erlanger. That's the benefit of the bargain. That's how she's getting paid here. It's not UT. UT's just furnishing her. And one other thing, Judge mentioned or asked a question about the malpractice insurance, which gets short shrift here, but I do think it's important because it was deemed part of her compensation, paid by Erlanger again. And Judge, if you go to page 51, which is the affiliate agreement, it's number 2.6 of the insurance agreement, it says that the university would provide the insurance. In fact, beyond that, as additional consideration, this is in the independent contractor reassignment agreement, trial record 85. In addition, consideration for professionals' acceptance of the terms and obligations created by this agreement, Erlanger shall reimburse each physician providing professional services hereunder for the expenses associated with maintaining professional liability insurance, or shall provide such professional liability insurance covering the physician in the amount and with appropriate limits as required from time to time. And Erlanger required this malpractice insurance in order for Dr. Dassow to have her staff privileges. What is the reason why Erlanger and UT would require malpractice insurance coverage if it's not for a case like this? The affiliate agreement makes clear there's only one way you can treat patients. You treat them, you submit a bill, you collect revenue, it goes into your salary, and by the way, we're going to protect you from malpractice claims. There's a whole section, 2.6, about even the affiliate agreement contemplated there would be claims for malpractice, and some would be outside the scope of the claims commission when the physician fulfills services for billing, which is exactly what Dr. Dassow did here. That's how the parties viewed whether the Claims Commission Act covered the services or not. And one thing I do want to add on, this was the trial court's conclusion on page 197 of its opinion. I'm sitting here reading this halfway through. I thought I'd won this case. It's the first paragraph at the top of the page of 197. The trial court says, If Dr. Dassow was a dual employee of both UT Medical Center and Erlanger, the resolution of this case would clearly fall under precedent of Hayden versus Waller. Clearly fall under it. If Dr. Dassow had also been employed by Erlanger, she would have received personal gain as provided by TCA 9-8-307 and therefore been exempt from the immunities afforded under the Board of Claims Act. The fact of the matter is, they conceded dual employment's not required.
Did I misunderstand you when I thought I understood you to say that they conceded that the doctor was a dual employer? Or was I wrong? What you conceded was that they conceded that dual employment is not required?
It's the latter, Judge. It's the latter.
Okay.
They have conceded.
My error.
Yes, sir. Page 27, they concede dual employment is not a prerequisite for personal gain. Well, if it's not a prerequisite for personal gain, just take the court's own order here. He found personal gain. He found Hayden would apply but for that. So our position is, by virtue of their concession, that now contingency's been removed. So if the court thought there was personal gain, why shouldn't you? But again, all we're trying to do is put forth some evidence to create a fact issue for trial. Thank you.
Of course, thanks to both counsel for your oral arguments this morning and for your briefs. We appreciate you. Recess court until this afternoon, please.
All rise. This court is in recess until 1:30 today.